The Splunk legal team requires that we share the following. As you might expect, we'll be making forward-looking statements about our business and financial performance during the course of this presentation. Those statements are subject to risks and uncertainties that are described in our filings with the SEC. We ask that you refrain from audio or video recording or rebroadcasting any of the content.
Hi, everybody. Welcome to our presentation, From Storming to Norming, AI Innovation and the Legal and Industry Standards Starting to Take Shape. You heard the automated legal disclaimer that just played right before this, but
we are on the legal team.
We are lawyers,
so we're very happy to see it there.
We have a couple more for you as well. Elizabeth and I both advise Splunk, Cisco on AI and other issues, but what's contained in this presentation is strictly our opinion and not necessarily the positions of Splunk or Cisco. And then the mandatory disclaimer is, even though we're both lawyers, what we're going to present to you today is not legal advice, even if I accidentally screw up and say the word advice. No advice, just opinion.
It happens.
Nothing contained in this presentation will create an attorney-client relationship. So with all
of that from your friendly legal team.
That will be the most legalese you get in this presentation, I hope. So let's do quick introductions. My name is Sam Olive. I'm on the Splunk legal team. I run our intellectual property department. That's patents, copyrights, trademarks, trade secrets, employment agreements, all the good stuff. I also advise on AI issues. I've been at Splunk about 6.5 years.
And I'm Elizabeth Fleming. I lead our product and marketing legal team, supporting a lot of stuff in the product and technology org and engineers. And I've been at Splunk for almost 8 years. But thanks for having us today. Thanks for coming to our session. We're really excited to be here. In the next 30 minutes, we're hoping to go over a few things. The first of which is to give you some general knowledge, give you some key themes, and some practical tips that we hope will help you navigate what is a really, really uncertain legal environment right now.
Yeah, so AI is a huge topic, and everybody in this room is going to interact with it in a different way and through a different role. And this is challenging because we really want this talk to be relevant to everyone who interacts with AI across their organization. So there's a couple of things that we aren't going to cover today. We are not going to give you a detailed survey of every proposed rule, every proposed regulation, every standard. You could do a whole .conf based just on going over the rules. The other thing we're not going to do, we're not going to have specific guidance for your business or for your execution plans. One of the really great things about Splunk, and one of the things that I've enjoyed about working here, is Splunk is relevant across every industry, and there are so many different ways to use Splunk. So we're going to try to keep this advice, see, I said advice, not advice. We're going to try to keep our talk more focused on general concepts that will be applicable no matter what you do. So what are we going to cover? We're going to briefly touch on key legal and regulatory movements. We're going to distill down some key themes from these. And we're going to provide you some practical tips, some practical considerations to help you navigate all the noise, all the uncertainty that's around AI. And then one other thing, we're going to be talking about AI generally, and AI is a broad concept. In some cases, generative AI will be specifically talking about that. We'll call out specific considerations, but a lot of what we're going to say is applicable both to generative AI and your more conventional, what we think of as artificial intelligence. So all right, let's get started. So why are we here? I mean, AI itself isn't new. We've been doing some form of AI at Splunk for over a decade. It's really been in the last 2 years that this Google Trends chart very nicely illustrates. We went from almost no interest in AI to explosive interest in AI. And it's not just that there's increased interest, because there's increased interest all the time. It's that it went from 0 to 60 in a hurry, almost overnight. Now, if you don't have an AI program in your company, or if you're not working on AI initiatives, you feel like you're falling behind. And that's relevant to us because what that's created is a landscape where the law is trying to catch up, where regulations are trying to catch up to things that are moving super quickly. And that creates a lot of uncertainty. Like I said, we could have a whole, did you go one too far?
There you go.
Perfect. As I said, we could have a whole conference dedicated to laws and regulations. But what we're really going to do is an overview of where the regulations come from, what they look like, and then focus more on the practical use, the themes and practical tips that will allow you to go back with some actionable items. So why are we talking about laws and regulations at all? Most of the people at Conf aren't even lawyers. Well, I think this quote that I'm actually going to read kind of sums it up. For company leaders, understanding the core principles underlying AI rules, even if those rules may not presently apply to them, can serve to instill confidence by customers and regulators in their use of AI, and thereby potentially provide a competitive advantage in the marketplace. It can also help companies anticipate the governance needs and compliance requirements that may apply to their development and their use of AI, which makes them more agile. And that's a quote from Ernst & Young that we really think sums up the philosophy of this presentation. Whether you're in legal or not, understanding the principles that underpin the rules and regulations will give you a competitive advantage. So if you're a CISO, if you're a legal person, if you're in compliance, these are the kinds of things you should be thinking about. And if you're a developer, if you're a product manager, if you're just someone that wants to incorporate AI into their business processes, knowing that this is how your legal, how your compliance department is going to be thinking will help you get, hopefully help you get approvals through quicker, help you get less friction in your own organization. So we are going to talk a little bit about regulations, and I'll put a little world map up here on the slide. We're going to focus really on the 3 main jurisdictions, and everybody across the world is regulating AI, but these are 3 that stand out. And again, we're just going to go over these pretty briefly. Start with the biggest one, the USA. United States regulations can really be divided into 4 main areas, I think. The 3 you learn in 2nd grade civics, your legislative, executive, and judicial branch, and then your state regulations. So for the
House Rock.
yeah, we're not that popular. So the legislative is easy. They aren't doing any serious AI regulation, or excuse me, AI legislation. Whether it's because it's an election year, because they're happy to sit and see how it develops, whatever the reason, in the legislative branch, it's really self-regulation. Now in the executive branch is where you see some more interesting things happening. In late 2023, the Biden administration put out a big executive order giving the administrative agencies marching orders as to come up with something for regulation of AI in your own organizations and in your own industries. Soon after that, a few of the major government agencies that are going to be regulating AI, the FTC, the EEOC, the DOJ, the Consumer Financial Protection Bureau, a few others put out a joint statement. And that joint statement said, look, we have the authority and we are going to regulate AI within our industry. And I think the other big executive one to look out for is NIST, the National Institute of Standards and Technology. They were mentioned specifically in Biden's executive order. And what they've come out with very recently is a generative AI risk framework. Now, all of that from NIST is still advisory, but it kind of gives you an idea of how our regulators are thinking about it. So that's the executive branch. In the judicial branch, you have a lot of cases, particularly on the IP side, which we're going to talk about. We have a lot of cases kind of winding their way through the courts slowly. Some of them are going to come out at different times and with different decisions. They're kind of just working their way through. So there are a lot of cases being filed. There's not a lot of concrete decisions out there yet. That's going to change. And then state law. There's a patchwork of state laws that are trying to kind of fill the gap between lack of federal legislation. And those come in kind of 2 flavors. There's some existing state laws that are not really geared towards artificial intelligence, but that are being applied to artificial intelligence. Things like consumer protection, child pornography laws, like customer regulation, anti-bias, those types of things at the state level kind of being applied to AI. And then there are a number of state governments trying to push through their own AI regulations. They're in all different. And again, you could do a 50-state survey that would be really interesting, but just know that these things are winding their way through state legislatures. So that's the United States. Let's shift gears a little bit and talk really quickly about the EU. Now, the EU, unlike the United States, is further ahead in terms of comprehensive and binding AI regulations. You all may have heard in the news media about the EU AI Act, the big act that they just rolled out. Now, that's going to be implemented in phases over the next few years, but part of it is already in force, and they're looking to move forward with regulation. Now, again, we're not going to go through the whole details of the AI Act, but one of the things to note is the way the EU has broken it out, they like to tier companies into risk tiers. based on the amount of risk that they view that company is creating by its use of AI and its use of generative AI. The higher the risk, the more regulatory burden the EU is going to impose on the company. And over the coming years, positioning your company at a certain tier of risk will kind of determine how much you're going to get regulated in the EU. So that's Europe. The last one we want to talk about is China. China's also put out evolving interim measures. And what they're really trying to do, they're trying to position themselves as creator-friendly in an attempt to bring more AI creators, to bring more AI generators into China. The Chinese view regulation as a way to maybe, in the short term, gain some competitive advantage over the EU, which has a little bit tighter regulations, and the United States, which has a lot of uncertainty and a lot of things still to be shaken out in the legal system. So that's a short overview of where the regulations are coming from. But like I said before, we're not going to focus on specific regulations. Instead, we're going to talk about some key concepts and themes to give you the tools to build out and implement your own AI programs, your own AI tools. And there's really no better person to give that advice than my colleague Elizabeth, who's been dispensing great thematic advice to Splunk for years.
Well, thanks, Sam.
I have a question for Sam.
Sure.
Yeah.
Do you foresee more of a global AI framework being adopted by the UN or something like that these countries will start signing on, or will they still be focused specifically in those regions?
I think they'll still be focused in those regions. I mean, I'm not familiar with what the UN is saying specifically, but for now, different countries have taken very different approaches. The United States, different EU's trying to push ahead. China's trying to position themselves as maybe a little creator friendly. So I'm not sure. I mean, the UN may well weigh in, but I think you're going to see development country by country basis, which is going to create some interesting, tensions and conflicts as the landscape develops.
But I do think you'll see international cooperation. We're already seeing, you hear all in the news, all the press conferences coming together for the likely, there's a lot of different things where they're coming together under common themes. So there will likely need to be some international cooperation, certainly, but cooperation. What? Yeah. But let me go ahead and start talking about some of those key themes. So I don't know exactly the makeup of this audience, but I suspect you've sort of dealt with in your organizations the push and pull between wanting to innovate, move fast, but then being kind of, you don't know all the rules. Like the rules are changing, it's a little uncertain, people are freaked out, or there's risk, et cetera. And so how do you manage that when there's, it's not quite clear what are the rules? And some people take super conservative approaches, just don't do it. Some people say, we don't care, we're just gonna keep doing it. But what's the middle ground? Like, what is the middle ground? How do we navigate that? So there's no magic bullet. Not one I'm familiar with. If you know it, let me know, please. But there's not one that I know. But if I could give one concept to sort of frame this conversation, our very short conversation today, it would be responsible. Be responsible. With AI, provides a lot of potential for productivity gains, innovation leaps, et cetera. But there's also a lot of major risks. Like, nobody can deny that there are risks. Not to be a doomsdayer, but there's bad that can come of this stuff, right? So what do we do when it's really uncertain? How do we move forward? How do we move the needle and continue to progress and not fall behind with all this uncertainty? So what we are kind of seeing a little bit is organizations, particularly in the United States, where we already tend to do this, is we're self-regulating. A lot of organizations are self-regulating and around the concept of being responsible. And so I want to pull out a couple, there's a lot of ways that we're doing this, a lot of ways we see companies doing this and organizations, but there's three things I want to talk about. The first is trust and safety frameworks. The second is transparency. And the third is, I'll just call it responsible IP, right? Responsible IP. Sam will go into that a little bit more. But so trust and safety, there's a lot of, as I mentioned just a second ago, there's a lot of fear, uncertainty, and doubt around the use of AI. And so what can we do to garner trust with the public, to dispel some of that fear and uncertainty? So here are kind of three things that some organizations are doing, we're seeing put in place. One are having responsible AI principles. Sometimes they're called trustworthy AI principles. You've probably seen these. Splunk's are privacy, accountability, transparency, resilience, and fairness. A lot of companies have different ones. They're very, very similar, and they all kind of come from similar places. But it's really a commitment to how are we going to engage, how are we going to use, deploy, develop AI at our organization. And then you have impact assessments. And I'll go into that a little bit more in a second. And then you have the fact that Sam had mentioned, at least in the EU, and we're seeing the more risk, the more you can expect you're going to have to do stuff to mitigate that risk or earn trust with the public. So as I mentioned, these are the principles, kind of the guiding stars, the North Stars to how you engage in AI. And then impact assessment. So what these are, many of you guys have maybe seen them, maybe interacted with them, not quite sure, but they document what you're doing. You assess it against your principles, figure out what risks they're presenting, and then you figure out what are you going to do to control or mitigate those risks. So it's an assessment to figure out how much risk are you really dealing with here, and how are we making people feel comfortable with what we're doing. So, like I said, they can be really long. I mean, this, I don't know, 78 pages is the general one, or the generative AI one has guidance. They can be really long, it can be short, but fundamentally, I posit that maybe you think about it as, at the very basic level, you're gonna wanna know information about data that goes in, at least in the generative AI's case. Data that goes in, the model that's being used, the data that comes out. And there's a lot of stuff that's gonna fall out of that and why it's gonna be important to look at those 3 key principles, or 3 key components. So it could be things as I have up here on the screen: who owns the data going in, how confidential is it, is there an IP right on it, how do you control for objectionable material going in. On the outside, you have who owns the outputs. What's the audience? Will they need a license? What are they going to use it for? And then information about the model itself. What's being used? Where is it hosted? What's its model card? What diligence has it done? And safety measures does it have in place? Can you explain how it works? Talk about why that might be important later as well. So again, just thinking about, there's so many details. We're trying to get the signal from the noise for you, but at minimum, you want to be thinking about the data puts in, the model, the data puts out. Okay, the next thing, this is related to the trust and safety frameworks, but I'm calling it out specifically because there's such an emphasis on transparency. And I mean this is almost like lowercase transparency because it has a lot of different facets to it. But people often fear what they don't know or understand. So you see a lot of push for making things more knowable and understandable. So this could be things like, certainly, explaining the model, explaining how it works, what input, what biases it could have, the context. But it also could just mean telling users that they're interacting with a chatbot that's AI, Gen AI. You see directly that coming out of the EU AI Act, but just generally letting them know that you're using it. Down to, are you collecting customers' data or users' data, and are you using it, and how are you using it? Because remember, as Sam said, other laws on the books are still on the books. So you have to, like, a lot of these things may push up against other laws, and so you have to kind of think of those as well. So anyway, transparency. So let me turn it over to Sam to talk to you a little bit about managing the uncertainty related to IP risks.
Yeah, I mean, the theme we're talking about today, using AI responsibly. And one of the big issues when we think about using AI responsibly is IP rights. And we're thinking about both your IP rights as you use AI and you use generative AI, and also the IP rights of others as you use generative AI in your own products, systems, processes. And unfortunately, or for better or worse at least, here in the United States, the IP rights associated with generative AI are largely going to be decided by the courts, and probably not the Supreme Court. They might do a case or two, but it's going to be a lot of different courts, a lot of different places, a lot of different types of cases across the country. And so far, the courts have said, well, we actually already have all the laws we need to regulate generative AI. We have existing copyright laws, we have existing trade secret laws, we're good to go. But anyone who's worked in tech knows applying old law to new technology, that takes some time to settle out. And sometimes that settling out period can be really rough. So you've got this place we're in now of legal uncertainty, but there's another layer of uncertainty when we're talking about generative AI and IP rights. So if we move on, generative AI combines a lot of different interests at this big intersection. You have the model creator, you have the author, or frankly, most time authors of the training data used to train that model. You have the authors of the prompts. You have the customer or yourself when you get that output of generative AI. All of those different people, all those different entities, they have some amount of IP interest in the output of that generative AI. And so you want to make sure that you're protected. You want to make sure that you've thought through your IP rights in this generative AI. But how do you do that in these with all this uncertainty and all of these different interested parties? Like Elizabeth said, there is no magic bullet. But in keeping with the themes we've tried to present to you today, if you want to responsibly handle IP rights, I think the best thing that you can do is know your data. And on this slide, I've called it the 5 W's of your data, but it's really whatever mental map you prefer. Whether you're a developer, a security expert, a legal person, it's incumbent on you that if you're gonna use generative AI to know what data is going in, where it came from, what's the provenance of that data, and what data is coming out. Where is it being used? Where is it being used in my organization? Is it going to be publicly posted in my organization? Knowing the who, what, when, where, why, and how of your data, or again, whatever mental model you prefer, know your data. Know where the inputs are coming from, where the outputs are coming from. You know, if you think about how we bring data in to a generative AI system, is it your customer data? Is it your internal proprietary data? Is it your engineering development data? Is it something you got off some website? You don't even know where it came from. Did you scan in a bunch of books or YouTube clips or movies? And then for data coming out, are you going to make that public? Knowing that you might have limited limited IP rights to that data once you put it on the website. You may not be able to exclude people from using the outputs of generative AI, depending on how different court cases settle out. You know, is generative AI output, is that going into your critical business processes? What happens if you need to make changes? And I bring this up for a mixed audience because this is not something that just legal teams are thinking about. If you want to get AI approved for your work streams, for your products, if you want to get this through your legal department, through your compliance departments at your own company, it's incumbent on the people. The lawyers are generally not going to know all this about your data. And so if you're the one pushing for AI, knowing the answers to these questions will help you get these things through faster and will help you get a way to use AI responsibly and convince your company that you can use AI responsibly and that AI can be used responsibly. So with that, we're going to settle into some practical tips, some takeaways, not just in the IP world, but across the use of generative AI. And so I'm going to turn it over to Elizabeth once again for some practical tips.
Okay, so we just walked through some really kind of hand-wavy themes and so be responsible, trustworthy, trust frameworks, transparency, be responsible with IP, know your data, know what you're trying to do. So here's some kind of practical tips. First is, consider, if your organizations don't already have one already, consider having a trust and safety framework. So consider having a program that ties all these things together. So it can start at the top with those principles I mentioned, those trustworthy AI principles that guide what your activities within your organization. Then it go to your policies, your procedures. So that include, do you do risk assessments, audits, whatever activities, committee approvals, whatever your activities may be. And then you have your use cases that you kind of run through the pyramid. You run through all of that. And what it does is having these things in place help you kind of hit a lot of the checks and balances that are going to be good for really proving out this responsible AI and potentially laws or regulations that may come online for you. The next, be transparent. It's clear. There's a public call to action to that. Whether or not a regulator tells you to do it, there's a public call to action to that. So it would be, inform your users if they're interacting with AI. Be able, whether or not you disclose it publicly, be able to explain how your AI system works, what data you're using, what the outputs are. Be able to explain not only that, but the context for it, what might be its limitations, et cetera. I mean, a lot of people put model cards out, and a lot of people do disclose a lot of information, but at minimum, make sure you know that information. And then, generally speaking, be upfront with your customers as always. Like the FTC is warned about like baiting and switching, or you've heard in the news articles of like, oh, they collected my information and didn't tell me about it, and they used it to train their model. Like, you don't want to be on that side of the news. So I suspect. So be transparent. The next is tag and document. So again, this goes back to, we don't know exactly what rules and regulations may or may not apply, or what standards may be expected of you based on your organization, your industry, your customers, et cetera. But at the end of the day, you should be keeping track of the information so you have it at the ready. It's a lot easier to keep track of it up front, what you did, what data you used, how the model works, how you trained it, tuned it, et cetera, up front, than to try to go back and say, I don't know. And like, I'm supposed to know that, and I'm supposed to adjust it this way. It'd be a lot easier if you keep track of it up front. And that goes with also like documenting outputs. So as Sam, it kind of ties into IP stuff. If you want to keep track of knowing when you used a particular model, so that it may have implications on whether or not you can use it later, how you can use it, things like that. You at least know those facts because you'll know what data came out of the model. Let me hand it over to Sam for the last few practical tips before Q&A.
Yeah, I'll take us home. So the next one, avoid AI washing. And AI washing, for those of you that don't know, is saying you're using artificial intelligence when you're actually not using artificial intelligence. Now, if you're here last week for Cisco Live, they actually mentioned this as a big concern, like where people are saying using AI, but not really using AI. And I guess there's this impression through the industry that, oh, I'm using AI, so I'm safe, it's brand new. And that's not the case. Like, existing laws still apply. And there is nothing a regulator likes more than taking an existing law and finding a new use for it. And so, false advertising, like making statements that aren't true, those are still going to apply. And yes, the law is taking some time to catch up to the use of AI, and it's taking some time to catch up to people that are saying, oh yeah, we've got AI here, and AI there, but it will catch up to you. And so this is something to think about now before the regulators. There has been some minor regulatory activity. I know the SEC has looked into a couple of people who are saying AI in financial disclosures and other public statements. This is going to continue to be a big deal because the regulators have signaled that they are going to be looking at this. So if you're not using AI, go ahead and start using AI. Just don't say you're using AI until you're actually using AI. And I think the next practical tip, be flexible and agile. Elizabeth talked about, how to build out systems that can adjust. Part of why it's hard to do a presentation like this is we know things are going to change. If we do this again in 6 months, it could look totally different. The landscape could look totally different. We might have to do a whole separate slide deck. But that's not an excuse to do nothing and just wait. You want to have an imperfect framework in place. That's better than not having any framework. And if you draft a framework properly, like Elizabeth talked about the pyramid, but again, whatever mental mapping you want to use to kind of layer your AI procedures, processes, the way you build it out, the way you use it, make it interchangeable, make it flexible, and make it agile. So that if you do have to change things, you don't have to take a sledgehammer to everything. You swap out one piece. You keep your principles in place. You keep your policies in place, and you keep moving forward. That is going to give you the most ability to have success in a very uncertain and changing world. And then lastly, I'm going to close it out with protect your IP. And I think IP, there's more.
Says the IP attorney.
Yeah. That's right. This is my wheelhouse. There's more uncertainty around IP than I think almost anywhere in generative AI, and rightly so. People are very concerned about, will I be able to use this? Will I be able to exclude other people from using this? And right now, I don't have a lot of good answers for you. No one does, because these things are still winding their way through the court system. So I think practical tips for IP, be judicious about where your generative AI is being used. And think about, it somewhat goes back to knowing your data, but it's also kind of taking a look at how am I using generative AI and what am I using it for, and does it actually make sense right now? There's this rush to use AI just for the sake of using AI so that you don't fall into the AI washing trap. But that has its own peril where it's like not everything should be generative AI, especially because we don't know for sure how protectable what comes out of a generative AI system is going to be. So that's something you want to think about. And then the last practical tip for AI, particularly if you're going to use a foundational model, if you're going to contract with an OpenAI or someone providing large, wide spectrum foundational generative AI models. Some of those companies will offer limited indemnification for IP. They will take on the liability of potential copyright infringement, potential other IP infringement. You may have to ask for those terms, but those terms might be available. And that's something that you can flag for your own legal and compliance departments. Be like, look, I understand IP is a risk, but if we go with these models, there might be some room to mitigate some of those risks with indemnification. The foundational models want adoption. They want people to use it, and there is some room right now. And again, these are all things that might change in 6 months, but right now there is some room to negotiate and get some conditional indemnification around IP rights. So that's it. We're out of practical tips. Thank you all for coming. And out of time.
We have a few minutes for Q&A, though.
We do have
so
some
if there's
Q&A,
anything that
but
anyone
I wish you all the best in implementing and getting approval for your own AI programs. I'm excited to see what everybody comes up with.